oversaw the delivery of a range of consumer financial products and services to union members. After leaving union privilege, he served as general counsel and executive vice president of Kessler Financial Services, a privately held company providing marketing and advisory services to financial institutions and their affinity group partners. Following passage of the Dodd-Frank Act in 2010, David joined the implementation team for the CFPB, and in 2011 was named Associate Director for the Division of Research Markets and Regulations. In 2016 to 2017, he also served as Acting Deputy Director of the CFPB. He retired in 2020 and now serves as Senior Fellow of the Center for Responsible Lending, Senior Advisor to the Financial Health Network, and an adjunct professor at the McCourt School of Public Policy at Georgetown University. He also serves on the advisory board of the Alliance for Innovative Regulation and as a member of the advisory committee of FinReg Lab. David is a graduate of Brandeis University and of the Harvard Law School. He began his legal career as a law clerk to Chief Judge David Bazelon of the U.S. Court of Appeals for the District of Columbia Circuit and Supreme Court Justice Thurgood Marshall. Tom, David, thank you very much for joining us today and welcome to the discussion.
Thank you. Thank you.
So let's just jump into these. I have a series of questions that I had thought might prompt some discussion here. And some of them I think are specific to the two of you, but many of them it would be interesting to ask of both of you. So big picture question, looking back over the first decade of the agency's existence, there's been tenures of different directors. There's been back and forth on policy development. There's been a maturation of the agency itself as it's grown in size and capabilities. That's a lot to process. And since our task here today is to evaluate the agency's legacy, such as it may be in the first decade of its existence, I will open this with maybe the broadest possible question prompt, which is for each of you, what do you see as the CFPB's biggest successes and failures, or maybe if not, you don't want to speak to failures, missed opportunities during the first 10 years. And with that incredibly broad prompt, I think I'll start, David, with you. I'd love to hear your experience and kind of objective view, having been at the agency substantially from its creation until just last year. What do you see as the agency's successes? We'll start with that, and then maybe missed opportunities or failures from your perspective.
Thanks, Brian, and thanks for having me. I'm not sure I can pretend to offer an objective view. I don't think anybody's ever accused me of doing that, actually. But let me offer you my perspective, at least. Yes, when I think about successes, I sort of think back to the first strategic plan that the Bureau put together in 2011. And we organized things into two big buckets. One was things we needed to do to build a great institution. And the second was things we needed to do to deliver tangible value to consumers. So an internal and external focus. So on the internal side, in some sense, I would say that the biggest success was actually standing up an agency in 12 months' time. It's not easy to overestimate the difficulty, particularly in a government setting, of going from a startup to, in 12 months, having to take over the responsibility from multiple other agencies responsible for enforcing a wide range of laws. So we started with no people, no building, no systems, no processes, none of that. And all of that had to be created in a 12-month period of time. So the fact that we went to bed on July 20th with no authority, no power, no responsibility, and woke up on July 21st with this massive amount of authority, and that we were more or less ready for that, I would say in and of itself is a particular accomplishment that I'd be proud of. And then I would say that if you think about, again, from the internal perspective, some of the specialized capabilities that we built out, not necessarily in the first year, but over time, that didn't really exist elsewhere in government, or at least to that extent, a consumer response function, which has handled millions of complaints from individual consumers, a supervisory program to supervise non-depository institutions. So there was a tradition of supervising banks, but to be able to supervise credit reporting agencies and debt collectors and finance companies and audit servicers and all that. That was a new capability. The market monitoring function we built, trying to bring people in from industry who had subject matter expertise, if they actually knew how these markets worked and could help understand what was going on and advise as to the implications of what was going on. We created the first Office of Innovation, what we called Project Catalyst, and then built a regulatory implementation function, which I think also was unique in trying to help industry work side by side with industry to implement rules that we were promulgating. So in the second bucket, in terms of what we accomplished for consumers, I suppose the first thing I'd point to is the work we did in implementing the Dodd-Frank Act, and particularly the mortgage provisions of the Dodd-Frank Act. There was a whole title of Dodd-Frank, which, not surprisingly, given the crisis that had preceded its enactment, adopted a whole myriad of new rules governing mortgage lenders and servicers. Those rules were, by the terms of the act, all self-executing. They would take effect in January of 2013 with or without any regulations, but the Bureau was authorized to postpone their effective date for 12 months if we issued regulations. So we issued 7 or 8 mortgage rules, which enabled us to both defer the effective date and provide for a much smoother landing than otherwise would have taken place, which I think succeeded in, on the one hand, preserving access to credit, avoiding disruptions, and at the same time, putting in a set of guardrails for the industry so that it's a more transparent, safer marketplace than it was before the Bureau got started. Can point to other things, I guess. I think perhaps the other thing I point to in this is we, through the research function, sort of defined a set of problems and advanced the understanding of a number of issues: who has access to the credit system, who's credit invisible, and who's left out, how people gain access to the credit system. What are the outcomes for people using small dollar credit? What are the outcomes for people using overdraft? Some of those we moved the needle from regulation, although I guess none of them in a permanent way so far, if anything's permanent in this area. But at least I think we changed the public dialogue and understanding of these problems. So let me stop there and pass it over to Tom.
Yeah, well, we can start with successes. Tom, what are your thoughts looking back over the last 10 years?
Sure. Thank you very much. And thanks for having me here today. I think I will agree with David and kind of, agree with many of David's comments, but emphasize 2 or 3 things that I think really stand out from the perspective of having been at a consumer protection agency that was trying to deal with some of the problems during the financial crisis and some of the things that we either couldn't do or couldn't do particularly well that I think the Bureau has done well. I think one is to emphasize the point that David made about non-bank supervision. That was something that was very difficult pre the stand-up of the CFPB. Very few agencies, if any, at the federal level really were engaged in supervision and examination of non-bank entities like debt collectors, credit bureaus. That deprived us of a lot of information that would be very helpful in policy making in the financial services area. And I think the Bureau doing non-bank supervision has been helpful. I think also given more technical, more minor violations, I think the supervisory function has been very helpful for agencies that in the past would have looked at some of these entities as being either bring a law enforcement action or not, having the option of dealing with some problems in non-bank entities through supervision, I think is a positive thing. Of course, like anything, there are costs associated with non-bank supervision. And I think that, you can have an argument about how the benefits from non-bank supervision stack up against those costs. But I do have to say, from the perspective of trying to do consumer protection work at a federal agency without some of the information that's available through non-bank supervision, it was much, much more difficult to do. The second thing that I would flag is something that David pointed out is the creation of the markets offices in research markets and regulations. I mean, this is bringing into the government for in-house assistance people with recent experience and expertise in particular business markets and using information from them to try to identify problems and to evaluate solutions. And from the perspective of someone who has tried to use tools, law enforcement, rulemaking, other kind of policy development where you didn't have that kind of in-house input, I think it really has been very valuable for the Bureau to have established that capability in-house and to have used it. There's nothing better than in a rulemaking to be able to go down the hall, knock on someone's door who has been in, let's say, a debt collection agency for years and say, we're hearing this is hard, we're hearing this is easy. From your perspective of actually working in this kind of a business, who's got the better of the argument? And I think that bringing that to bear on issues at the Bureau has been extremely helpful. The last issue
let me jump in there. So do you think having the markets team within CFPB, materially improved the policy development process and thereby the rules or other kind of policies issued by the Bureau, in as much as it helped better shape those activities based off of a better understanding of the market?
I think I would say the answer is yes, because the markets offices are always bringing to the attention of decision makers both potential problems and views on the merits of decisions. They probably have had less influence in some circumstances and some issues than I would have preferred, because I think I am very amenable to many of the kind of arguments that they'd like to make on policy issues. But that being said, I think it's incredibly valuable for the agency to have had that perspective shared with the heads of the agencies so that they can decide what they want to do when they make a choice. And so I think that really is an innovation that the Bureau has developed, and that I think it actually has been valuable to government decision making.
So turning back to part B of the first question, which is failures, setbacks, missed opportunities. What's your thinking there, David?
So a couple of thoughts, Brian. One, we did not succeed in depoliticizing the agency. Whether that was possible or not, I don't know. There's always going to be, legitimate, bona fide philosophical disagreements as to what role government should play in regulating markets. And those are real and legitimate, and there's no way you're going to sort of get past those. But whether we could have, had we approached things differently, taken some of the heat around that, and so that there could have been reasoned discussions without it being as contentious and as adversarial as it was, I don't know, but certainly look back and say that that's the potential missed opportunity.
I would agree wholeheartedly with that. I mean, that was the largest failure that I could, or challenge that I could identify as well, is that, after a decade of existence, taking all of the actions, spending all the money the Bureau has spent, there just is not the broad-based bipartisan support and trust for the agency that I think would be extremely helpful in dealing with these issues. Like David, I think we could probably debate all day who's responsible and whether it can be remedied. But I think the fact is that 10 years into its existence, the CFPB still just does not have that kind of general support that would be so useful for its credibility and its effectiveness in dealing with the public.
I mean, I would say I think that the debate has probably shifted a little bit. There's not so much should the CFPB exist, which was in 2011, one could have envisioned a world in which the statute would be repealed and the agency would have been replaced and authorities pushed back to the agencies that had them. I think we're past that point. I think the Bureau is established to that extent, but I agree with Tom that we're not, that there's still widespread skepticism, and that it's something that would have liked to have seen done better.
So one aspect of that is, of course, culture. And in the prior hour, I spoke with Kathy Kraninger a little bit about culture, and she had said, in essence, that one of her missed opportunities was not having enough time to focus internally on culture because of COVID, and some of the plans had been put on hold that might have otherwise taken place with a consolidated office within Washington, D.C. So let me pick up on that a little bit. I don't know the extent to which the agency's culture is linked with the external perception of the politicization of the Bureau or not, but what strikes you when you think about the Bureau's unique culture? Tom, for instance, what do you think distinguishes the Bureau's culture from, say, FTC or other government agencies? And has that changed over time? From kind of the beginning days through the leadership transition process.
Well, I can get us started. I mean, obviously, it's a bit of a challenge to speak to culture of an organization with 1,500 individuals. That being said, if someone asked me to come up with adjectives that I thought described the values that are usually part of the CFPB culture, I think the CFPB values intelligence, hard work, inclusiveness, data, and process. Those are the sort of ideas that come to mind for me when I think of a CFPB culture. A couple things I would emphasize. One is I think it does vary a lot by organization. Take, for example, the idea of how the culture in various shops approaches legal risk. I think you have a continuum on which you could put each of the shops that have lawyers. I think they have a different role, a different function, and that feeds into a culture as to how much they are risk averse or how much risk they prefer. And I think you see that coming out of some of people's expertise, some of their backgrounds, some of the rules of organizations. And so I think that different parts of the CFPB have different cultures as well. Let me address kind of head on the one question you asked about, the CFPB culture being too ideological or partisan. In my experience, there certainly have been some CFPB folks who I think have thought that their job was to bring to fruition, progressive view for the agency, especially when it comes to issues on which they feel passionately about, things like payday loans or fair lending or overdraft fees. But that being said, I think that most of the people who have that kind of a perspective are the exception, not the rule at the agency. And I also think that a lot of that has decreased over time, especially during the tenure of Director Kraninger. I'd offer two caveats as to my thoughts about that. One is, most of my experience at the CFPB has been in research markets and regulations, and I don't know whether their views are representative of everybody throughout the Bureau. The other is if people are interested in kind of where the CFPB is today on those issues. I've been gone from the CFPB since January, and so I don't know whether the culture has been modified since my departure. But that's sort of my general take on where the CFPB is as a matter of its culture.
Fair enough. David, anything to add there?
I like Tom's list of adjectives a lot. I guess I would add one, and this may prove conclusively that my lack of objectivity, Brian. But from my perspective, there was an open-mindedness and a willingness to admit error and to change our minds. So when we issued the mortgage rules that I talked about, for example, we knew that in the period of time we had available, we hadn't gotten everything right, and went through a series of rulemakings over the next year to try and listen to feedback, find out what were problems that weren't going to work, and make adjustments and tweaks in the rules to try and make them work better. We took we'll talk about this later, maybe, we took the comment process very seriously and learned from the comments and adjusted what we had proposed based on that. And there were times when we issued, even to the point we issued a study and somebody came in and said, you got that wrong, you misunderstood the data. And we said, you're right, and we corrected the data. And towards the final part of my tenure, when we were called upon to do 5-year assessments of the effectiveness of the rules, we took that very seriously as an opportunity not to whitewash and say, yeah, everything's great in the best of all possible worlds, but to say, here's where the rules achieve what they were intended to achieve, and here's things where we think, we actually did create some access to credit issues, for example. So I would put that as part of the culture as well.
Well, I guess that's a good jumping off point. You both have mentioned the rulemaking process. Obviously, that was your substantive area of responsibility, among some other responsibilities as deputy or acting deputy. But let's focus on the rulemaking process a lot. So both of you, helped shape the rulemaking process internally. Had the responsibilities for gaming out which rules take priority over time, how you're going to staff those. Can you share a little bit, pulling back the curtain, so to speak, on the rulemaking process and just, in an executive role managing that process, what are the considerations in place? Because, the public on the outside usually sees just whatever the proposed rule and the final are. And so, you can think about, okay, that's another 850-page rule from the CFPB, and it took 3 years or 7 years or still ongoing, rulemaking processes from the beginning. So it's kind of hard to understand that process, understand the considerations that go into it, when all you see is kind of the end product and the amount of time it took, and then have to work through, all of the sunk cost in, upgrading compliance management systems or hiring folks on the outside to translate for you, what that means from an institutional perspective, from a consumer's perspective, understanding, how transactions are affected and what maybe new opportunities there may be. A lot goes into that. It seems to be kind of a shadowy world as regulators on the inside working through that process. Do you have any thoughts or perspective on that process, and what would you share with the public about the challenges and maybe areas for improvement in the process? Tom, you want to go first?
Sure, I'll give it a shot. I mean, I think, I don't think the public really appreciates how iterative, deliberative, and inclusive the CFPB rulemaking process really is. Whether you're talking about, an ANPR, a NPR, a SBREFA outline, a final rule. For each of them, there are policy decisions that have to be made. And what happens is essentially they come from the grassroots at the agency and work their way up. So they start, and it really is a vigorous debate among lawyers, economists, and the like, and business folks in RMR as to what's the right policy result. And then they start working it up the chain of command to go towards the director. And so every time you go up and the director makes a decision, then you go back and you start drafting the documents to implement it. Sometimes the director changes his or her mind. Sometimes the team decides that a decision that was made needs to be rethought. And then you go all the way back up the chain again to the director. And so there is this incredible iteration of policy issues and drafting and input that goes on that takes a long, long time, especially when you have rulemakings that involve a host of issues. It's also incredibly deliberative. I think one of the things that people don't appreciate, and you alluded to this, Brian, is that a lot of times the public sees what pops out at the end of the day. And what they don't realize is that internal to the agency, there may have been 3 or 4 or 6 different positions on an issue that have been debated back and forth among people at the Bureau, and ultimately the head of the agency makes a cut. But there really is an internal deliberation that goes on that can be quite spirited. People have different views. And yes, everyone coalesces around what the agency's position is once the agency director makes a decision. But there is a lot of deliberation, discussion, and debate that goes on before you get there. And the last one is inclusive. One of the things I don't know that everyone appreciates is that, while research markets and regulations really kind of germinates and develops rulemaking proposals, rulemaking ideas, every single one of these rulemakings that goes through, all of the other shops at the agency have an opportunity to share their views about the merits of what's in these rulemakings with the team, with the director, et cetera. And so when something comes out at the end of the day, a lot of times I get questions from people like, did your enforcement shop actually see this? And the answer is yes. Everybody at the Bureau sees it. It's very inclusive as you go through the process. So to me, that's the rulemaking process is long, complicated, and I think sort of trying to capture the iterative, deliberative, and inclusive features of it are things that I don't think the public a lot of times really appreciates.
David, anything to add there?
I'll talk to another part of your question, Brian. I think Tom's done a good job of explaining the process and perhaps answering the question of why it takes the time it takes.
Yeah.
You also asked about why are these so long, basically, and that's certainly something you hear a lot. But I think if you peel it back, so take the payday rule, for example, which was 500 pages in the Federal Register, probably, so 1,600 pages of printed text, one of the largest, biggest in terms of volume of pieces of paper. Of those 500 pages, 13 pages were actually the rule, the regulatory text, which said, here's what thou shalt not do. There were another 30 pages, which were what are often colloquially referred to as commentary or official interpretations, an attempt to elaborate, to provide examples and illustrations and elaborate so that there would be less question about what the regulatory text says. And the other 450 pages were a little bit of background and a lot of a section by section analysis explaining, here's what we proposed, here's the comments we received, here's the changes we've made, here's why we haven't made changes, here's why we agree with the things we heard, here's why we disagree with the things we've heard, followed by a cost benefit analysis. So that, in order to do that transparently and thoroughly, and I think there are ways to streamline it. I don't think the process the products need to be as big as they are, or the process as long as it takes. But the answer as to why they're so long is because the Bureau has attempted to provide this very thorough explanation of where they were, where they've landed, why they landed there, and how that relates to the comments they received.
I'd like to add one additional consideration that I think drives the length and the timing of the rulemaking process. It's how big a scope does the Bureau decide to undertake when it takes rulemakings? I mean, you can proceed very narrowly and incrementally. You can go big and try to deal with a lot of issues and tie them up and handle them all at once. I think David and I probably both know from having been part of the rulemaking process, obviously, the more issues they add, the more complexity you add, the longer the rulemaking documents get, the longer they take. And so you can have a debate as to whether what you want is rulemakings that are quicker and rules that are shorter, perhaps having the scope of the rules you start with narrower may help with those issues too.
Well, point taken. I wish we were in a world where you could just read the rule itself and go from there. But from a compliance perspective, I think there's necessary insight from considering the interpretive rules or staff interpretations that are associated with it. Also, understanding the agency's thinking, and you can learn as much from why the agency elected not to pursue an alternate path, I think, sometimes. So all interesting. Maybe folks on the outside could just assume and ignore the cost benefit analysis once the rule is finalized. But it seems that mostly all of the material is somehow insightful or useful or should be reviewed. Interesting point. So going to Tom, I did have a question for you. You were basically the top of the consumer protection function at FTC, and then also sat as deputy in a co-division head at the Bureau. Aside from the obvious structural and funding differences between the agencies, and to some extent the FTC's antitrust function, but thinking just about the consumer protection approach, are there any significant distinctions or differences you would draw between how the two agencies go about their consumer protection missions?
Sure. I mean, I think one of the things to recognize is that the FTC over the past roughly 40 years has really transformed itself from being a regulatory agency to being primarily a law enforcement agency. So probably the best apples to apples comparison between the CFPB and the FTC is to look at what their enforcement divisions does at the CFPB as compared to the Bureau of Consumer Protection, Division of Financial Practices, and to some extent, the Division of Privacy and Identity Protection. And I think that there are really kind of three main things that I think address how a staff attorney or a manager in one of those shops would look at consumer protection problems. I mean, the first difference is that at the FTC, there's the Bureau of Economics that weighs in with a separate and independent analysis assessment of every single case that an FTC staff attorney or first line manager wants to take up to the commissioners. And so you will always have people who are offering a separate view as to the economic consequences of what your case is, what the economic incentives are, what the effects on competition may be. So certainly by the time it gets to an agency decision maker, the lawyers in the Bureau of Consumer Protection at the FTC have to be mindful that there's going to be this economic assessment of what their case is in a way that really doesn't happen at the Bureau. The second thing that I think I would note is that it's a little different in that the CFPB divides up its staff by function. You enforce cases, you write rules, whereas at the FTC, all of those functions are within the same group of attorneys. So if you have a question that comes up, consumer protection problem, and an enforcement attorney at the CFPB sees it, primary function of the CFPB attorney is to try to figure out whether a case should be brought or not. FTC attorney who's looking at it, they're far more likely to say, hey, it's my job to think about, should we do a case? Should we do a conference? Should we start a rulemaking? So the lawyers who work on individual consumer protection matters at the FTC, I think, are more attuned to the idea that there are more possible tool choices than a lot of the lawyers in the enforcement shop at the CFPB would have. And I think the last one, I think, kind of it goes to something you mentioned, is that I think the structure of the agency affects how people who are putting together potential cases view things. I mean, at the CFPB, you've got an audience of one. The director ultimately is the person you have to persuade, and you kind of know what the director's point of view is. If you're at the FTC, you take a look at it and you have 5 commissioners, no more than 3 of which can be from one political party. So you look at it and sure, you could probably try to get your case voted out 3-2 or something. But most of the time what FTC staff attorneys are doing is trying to find a way of articulating a rationale for their case that's going to appeal to, a conservative Republican as well as a liberal Democrat. And, the case may be the same as it would have been otherwise, but one of the things it really forces FTC staff to do in a way that I don't think CFPB staff does is try to figure out the different prospective audiences that may be confronted with enforcement action and what would be persuasive to them as a reason to proceed. So there are some differences between the two agencies, how they do their enforcement function and how their lawyers evaluate issues.
Thanks for that, Tom. David, separate question for you. So you've been at the agency, were at the agency, experienced changes in leadership, both kind of inter-party and then inter-party. From the early days of Senator Warren standing the agency up from the Bureau opening, its doors up, interim leadership until Director Cordray was confirmed. Now we've had 2 confirmed directors, maybe soon, hopefully we'll have a 3rd confirmed director plus 2 acting directors in the interim. Within, an agency that is experiencing, that kind of leadership turnover and changeover, I imagine there are lessons learned from that transition process. And looking back over the 10 years, I imagine some of the transitions have been rougher and some have been smoother. And maybe my perspective is it's probably a learned skill for an agency to go through that from a leadership perspective. But I'm curious to know your thoughts on, that changeover in leadership process at the top within a young agency, experience it maybe for the first time, but then experiencing it multiple times. And what are the lessons learned there? And how do you, what would you say is the way to get the process right so it's a smoother transition in the future going forward?
So I guess, Brian, I think that, first thing I'd say, I think you're right. Transitions are hard, and they're probably particularly hard for an agency which has not undergone them before. So that was not standard operating procedure, not something, not part, there was no muscle memory, no institutional memory. One of my colleagues who was a career servant, civil servant, had been through transition to other agencies. One of his first piece of advice was to understand that political leadership do not come with an owner's manual. And it's up to staff to sort of understand what it is the political leaders want, not just substantively in terms of what are their priorities and their philosophy, but also how do they like to work? Do they want long memos or short memos, footnotes or no footnotes, big meetings or small meetings, all those sorts of things, just to learn how to work effectively with your new leadership. Mm-hmm. And there's not a formula. The formula is to try and understand that everybody is different. Then you need to understand what they bring into the table and what their expectations are. I guess the second lesson for me is that building trust, which is what I think is critical to a successful transition, is hard work. And it's hard work on both sides. It means the career staff have to accept and convey that they accept the legitimacy of the political leadership and their right and responsibility and duty to make decisions based on their perspective on, in our case, what best serves consumers and the interests of consumers, and that's going to differ from leader to leader, administration to administration, so that they are aligned with, they don't have to agree with, but have to accept that their obligation is to give their best advice and the evidence they see, and then to accept decisions and implement them. And it requires, I think, and I wasn't on this side of the table, but some leap of faith by political leadership, or maybe even suspension of disbelief, and to be willing to believe that the career staff who yesterday were working for somebody with whom you may disagree quite profoundly on philosophical issues, and who are doing the best they could to implement Rich Cordray's agenda, if you will, that they have accepted the fact that they have a new leader and that their responsibility is to implement your agenda, and to give them, to trust them to do that. I think that's key, and that's really hard. And I don't know any easy formula that makes that easier.
That's interesting. I mean, speaking of no easy formula, turning for a second, I think one of the central considerations facing any director, or by extension a senior leadership team, and certainly will be a consideration for the Bureau in the future, is this question of resource allocation. Now, maybe it's a special case in the stand-up of an agency where the Bureau has a statutory maximum of funds they can draw in any given fiscal year, and so the question is maybe different at the outset, which is how do you stand up an agency? But as the agency reaches some level of maturity, or is on a steady state operating basis, at some point you bump up to resource allocation questions, and there the question is which of the agency's fundamental tools you use, and undoubtedly different directors will have different views of how to balance that. But you have supervision, you have enforcement, you have educating consumers through consumer education or financial literacy programming. You have the rulemaking function, which you all understand inside and out. Do you have any generalized thoughts or maybe advice on approaching that central question? I mean, it strikes me that at some point there's no right or wrong answer, because it's in essence a balancing test. But looking back on the agency, maybe a different way to think about it is, had the agency allocated resources in a different way? Are there ways in which it could have improved, outcomes for consumers or the policy development process? So, again, generally thinking, how do you think about tool choice and the balancing of, the agency's substantial powers and authorities? In your experience there, were there takeaways or lessons learned, or, looking back retrospectively, do you think anything could have been done differently?
Maybe I can start it,
Okay.
I guess I would start at the beginning. There are certain things that Congress mandates the agency must do. And from my opinion, those should go to the top of the pile above anything that's discretionary. And Congress has spoken as to what rulemaking should be done or other actions the agency should take. Those should come first. You get beyond that, from my perspective, I look at it primarily from the perspective of what's the most efficient way of preventing consumer harm. You look at whatever proof you've got of consumer harm in marketplaces that's coming from bad actors or from rules or standards that are unclear, lack of information out there for consumers or businesses, and you try to figure out what's the best tool, the most efficient tool to deal with the consumer protection issues that are causing the largest harm. To me, where I see this is being a difference across administrations at times, it's really kind of what you do when the law is not clear. I think there's pretty broad agreement. If the law is clear and you've got conduct that is unlawful, it's harming consumers, I don't think any of the people who have run the Bureau would have hesitated to say that's when Cephal's tool should be used, whether it's supervision or enforcement. I think the question comes up when the law is less clear. How do you approach that? And from my perspective, absent some need to bring a case to stop ongoing harmful conduct or to get financial recourse that's helpful for deterrence or consumers, I think the general standards to deal with where the law is unclear and there are consumer protection problems in the first instance is something that should be addressed primarily to the rulemaking guidance process in RMR rather than through law enforcement or supervision. I think that you may see some differences of opinion over time based upon who is the director as to how interested they are in trying to solve consumer protection problems through rulemaking and guidance as opposed to law enforcement. I think, but I think that's probably the point where I think there is some difference. When there really is a clear law violation that's causing harm, I think that there is bipartisan consensus, and it's been uniform across directors that that's something the agency should put a stop to as quickly as it can.
So, I think the devil always is in the question of how clear is clear enough for, nobody. I think, as Tom was saying, there's on the one hand, there's the extreme that, look, you can point to this statute, this rule, and this is within the four corners of the statute, the rule, what you're doing violates it. No question that's a matter for enforcement or supervision. The choices, there's choice among those. At the other extreme, where nobody would have understood that this conduct is unlawful, that to bring enforcement action would be essentially inconsistent with any kind of notions of fair notice. Mm-hmm. And the hard problems are the gray areas where you have generalized norms. You shall not do something that takes unreasonable advantage of consumers' lack of understanding or inability, whatever. You have conduct, and you don't have something you can point to which specifically says, yeah, that sentence says this conduct is unlawful. So you take a case like the Wells Fargo case involved where the bank employees opened up accounts for people without their consent in order to make incentives and stuff like that. There was certainly nothing you could point to that said squarely, this is an unfair practice, this is an abusive practice. You had to reason from general principles. But I don't think anybody actually, at any of the regulators, thought that, gee, we should wait and write a rule that says you're not allowed to open accounts for people unless they ask you to open accounts. And indeed, if you had said to us prior to the Wells Fargo case, of the various questions raised in the law, what questions do you think you need to pin down by rule? I don't think anybody would have come up with that hypothetical as something that we needed to actually adopt a rule on. But it felt like that was the right choice. And I suspect that's a choice that would have been made consistently across administrations on that question. But that, as you know, at the margins, there will be different calls made by different administrations as to how clear is clear enough, and how much, how much do people have reason to expect that this is unlawful. It's noted that the Bureau did not, if you looked at the body, the Bureau's, the corpus of the Bureau's supervisory enforcement work during the Cordray years, there's virtually no cases involving payday lending, because a judgment was made that really we needed to have a rule that it was not clear enough what the norms were. And so that was there were no cases involving overdraft. Because again, that felt like other than rule cases enforcing the existing opt-in rule that the Fed had issued. There were cases in the debt collection area where there was rulemaking going on. There were some cases in the mortgage servicing area where there's rulemaking going on. So there was, different judgments in different areas, and as I say, different people would come out different places.
Yeah, I fundamentally agree with that there is an area where the law is uncertain, and that there are circumstances where in the face of that uncertainty, it's necessary to bring a case, as opposed to doing things through promulgating general standards. When those circumstances are not met, however, I think there is value to trying to find a way of coming up with general standards so that you don't get the surprise gotcha component of actions that are taken. And particularly for an agency that has a UDAP authority, UDAP by its nature is something that's relatively elastic, and you're going to have to develop it one way or the other through rules or through cases. So you will always be trying to figure out ways of dealing with new fact patterns that don't necessarily track the last fact pattern. And it's really kind of a judgment call as to when you need to bring a case to establish that some conduct is unlawful, as opposed to taking a broader perspective and doing it through rulemaking.
Well, I think Wells is an interesting case there, because I think the Bureau could have, had it elected to, if my recollection is correct, investigate whether there was a FCRA violation or truth in savings or truth in lending or other associated violations in connection with the unauthorized opening of an account. I think went with UDAP as the primary theory of the case, but undoubtedly there are questions and resource issues that are inherent in any sort of those judgment calls that are made. I see we are unfortunately bumping up at the top of the hour. I will turn, I guess, to one final question here, which is, you all have lived and breathed CFPB in one way or another have been close observers over the past decade. We may soon have a newly confirmed director, but undoubtedly we'll have additional directors in the future. If you got a phone call and were asked for advice about the agency, in view of the first decade, what would be the advice you'd give to a future director? David?
So I guess two thoughts here. One, going back to something which we sort of said at the beginning, I think the supervisory process is a critical tool that needs to be carefully husbanded and protected. It's important. There's a balance that gets struck between establishing supervisory relationships, which allow for free flow of information and confidential communications without it becoming co-opted in some way, without the regulators becoming sort of an arm of the institution, and trying to preserve supervision and that authority and its credibility and its effectiveness, I think, is a key priority, should be a priority for any director. The other thing I would say, again, going back to something we talked about, when it comes to rulemaking, time is not infinite. Time is not the friend of any director. The more focused rulemakings probably makes sense. Not to allow the perfect to be the enemy of the good, and to try and establish timelines and meet those timelines so that these processes don't take as long and lead to this cycle of rules getting promulgated on the 11th, the 23rd and a half hour, and then getting reconsidered on the 25th hour or whatever. I guess those would be my the two pieces of advice.
Thank you, David.
Yeah, I'd like to offer some advice that I'm pretty sure is unlikely to be heeded by anyone, but I'll throw it out there anyway. I mean, my advice to future directors would be to try to focus the Bureau's efforts on real demonstrated consumer protection problems and proceed very carefully and incrementally in dealing with them. I think that the clarity of some of these problems and the prudence reflected in proceeding in kind of a measured way would really enhance public trust in the Bureau's work. I realized that that kind of deliberate, go slow, be specific approach is not all that appealing to many new directors. But, I really think that kind of pragmatic, focused, problem-solving kind of approach is a key part that the Bureau needs to engage in if it really wants to build public trust, not just public trust of people who share your ideology or share your partisan point of view, but have everyone think that the CFPB is a valuable agency that serves the American public well. We need to get that trust component fixed. And I think that focusing on real problems and real focused directed solutions is the way to try to achieve some of that trust that is so lacking.
Well, this will wrap up our panel. Gentlemen, thank you so much for the opportunity to speak with you today. This was a great discussion. We'll move now to a short break before our next session. Next session is entitled, What Does the CFPB's Future Hold? It begins in 4 minutes at 2 p.m. Eastern. Please note that to join our next session, you will need to use the registration link that is specific to the next session. If you haven't registered yet, you can check the event page on the Federal Society website where you can register. We'll see you again in 3 minutes now. Until then, we're adjourned. David and Tom, thank you so much again. I really appreciate it.
My pleasure. Thank
Welcome everyone to the final panel of today's event, today's conference on the CFPB entitled The CFPB Turns 10, Evaluating America's Youngest Federal Financial Regulator. We've had 2 events already today, an address from Director Kraninger and a panel discussing what is the CFPB's legacy. Our final panel entitled What does the CFPB's future hold will take place at right now with our panelists, whom Brian Johnson will announce in just a moment. Brian Johnson is a member of the Federalist Society's Financial Services and E-Regulation Practice Group, and much more could be said, but I will just hand the floor over to him so that he can introduce our panelists. And we're very pleased to welcome such a great group this afternoon. So without further ado, Brian, the floor is yours.
Thank you, Evelyn. Welcome back, everybody, to the conference. This panel is entitled, as Evelyn mentioned, What Does the CFPB's Future Hold? The U.S. Supreme Court's decision in Selah Law last year struck down statutory conditions on the removal of the CFPB director from office as a violation of the Constitution's separation of powers. The Biden administration used this decision to change the leadership of the CFPB 6 months ago. This panel will discuss the priorities and actions of the CFPB under new leadership and the expected priorities of the agency under its next confirmed director. The panel will also discuss what should be the future direction of federal consumer financial law and CFPB policy going forward. Specifically, how should the CFPB or consumer law and policy be reformed to improve consumer welfare and the efficient functioning of consumer finance markets? I am very pleased to introduce our panelists, all of whom I know. Nancy Weisgold, my colleague, is co-leader of the Alston & Bird's Financial Services and Products Group in the firm's Consumer Financial Services team. She maintains a national practice focused on matters relating to consumer financial products and services, and represents clients, including mortgage servicers, well banks, non-bank consumer lenders, technology providers for the consumer financial services industry, AMCs, and investors in federal and state regulatory, supervisory, and enforcement matters. She acts as regulatory counsel in connection with investments or acquisitions, performs compliance due diligence. Nancy is frequently called upon to provide litigation support and assist in the development of compliance management systems. Professor Todd Zwicky is George Mason University Foundation Professor of Law at George Mason University Antonin Scalia School of Law. He's also the Senior Fellow at the Cato Institute. He's the former Executive Director of George Mason's Law and Economics Center. In 2020 to 2021, he served as the chair of the Consumer Financial Protection Bureau Task Force on Federal Consumer Financial Law, and in a prior life, served as the director of the Office of Policy Planning at the Federal Trade Commission. Professor Christopher Peterson is the John J. Flynn Endowed Professor of Law at the University of Utah's S.J. Quinney College of Law, where he teaches contracts, commercial law, and consumer protection courses. He was on leave from 2012 to 2016, serving as a special advisor in the Office of the Director at the CFPB, in the Office of Legal Policy for Personnel and Readiness at the Department of Defense, and as Senior Counsel for Enforcement Policy and Strategy in the CFPB's Office of Enforcement. He also works as a consumer rights attorney for, attorney for U.S. PIRG in D.C. and clerked for the Honorable Wade Rohrbree, sorry, I'm going to butcher that name, on the U.S. Court of Appeals for the 10th Circuit. It is an honor to speak with you all. Thanks very much to each of you for joining our discussion for the third hour of this conference. Welcome, everyone. So the first prompt here, I think the best way perhaps to spend our time thinking about the future of the CFPB is maybe to bifurcate the discussion and talk about first, what do we know about the CFPB's new leadership and what should we expect from a policy and activities perspective? And then maybe take a step back after exploring that area and think about the more normative question, which is, okay, we understand, from during this conference, the actions that Director Kraninger took and the actions that the Bureau took in the first 10 years. We have a good understanding maybe of where the Bureau will be going in ensuing months. But stepping above that fray a little bit, what should be the future direction of the Bureau? Where should its enforcement and supervisory or rulemaking priorities lie? What should shape the policy development for the agency going forward? And each of you are experts in your field, think about this practice in these areas. And so think about it from different perspectives. And I really anticipate that this will be a very interesting discussion going forward. So with that game plan in mind, let's tackle this first question here, which is, what should expect from the CFPB's new leadership? And maybe the best way to start is to take new leaderships at their word in terms of what they're saying their priorities are and what they intend to do moving forward. And there's been no shortage of that type of communication over the last 6 months. So, Nancy, why don't I turn this over to you first, and would love your thoughts on what the Bureau's priorities are now, what you are hearing from leadership and the direction of rulemaking or enforcement and policy development from the agency going forward.
No, absolutely. Thank you, Brian. And thank you, the Federalist Society, for inviting me. Delighted to be here today. So at the Bureau, as we know, we have acting director. We don't have the confirmed director yet. Acting Director Uegio has written quite extensively about his priorities. So he's articulated two main priorities. The first one is the relief for consumers facing hardship due to COVID-19 and the related economic crisis. And the second one is addressing racial equality. With 6 months under our belt, the acting director has written fairly extensively, or I'd say extensively, about these priorities. And I also have observations with working with several companies in front of the CFPB and how they translate. So let me share some of those thoughts. And as Brian said, I'm going to focus on supervision and enforcement, consumer education and outreach, and rulemaking initiatives. Starting with COVID-19, we're already seeing a shift to more aggressive use of supervision and enforcement tools and overseeing companies responsible for COVID relief. As Brian said, I represent a lot of mortgage servicers, but I also engage in student loan services and my partners in auto loan services. We also work with banks that are taking PPP applications. And in all of those areas, what we see is that the acting director has directed supervision, enforcement, and fair lending to always determine the full scope of issues found in exams, systematically remediate all of those who have been harmed, and require companies to change policies, procedures, and practices, to root causes of those harms. We are seeing that today in the form of MRAs, which are matters requiring attention that are sometimes issued with regards to examinations. Second, in May 2020, the CFPB supervision program conducted priority assessments in response to the COVID-19 pandemic. And priority assessments were slightly different than examinations in that they were designed to receive information from a broader group of supervised entities and kind of look at bigger picture issues. Now what we're seeing is the initiation of more targeted follow-up of exams of issues identified in those prioritized assessments. So we're seeing lots of companies getting information requests for examinations. They've also the directors called for the expedited enforcement of investigations relating to COVID. And in this regard, and I'll say I don't see this as necessarily COVID related, but with regards to investigations generally, we're seeing the increased use of investigative hearings, which is basically a deposition to basically speed up the enforcement actions. The last two things I'll note quickly on supervision and enforcement is the acting director has indicated that he is directing to reverse policies of the last administration that supposedly weakened enforcement and supervision, as well as to supervise lenders with regard to the Military Lending Act, presumably I would say under the UDEP authority to do so. With regard to consumer education, I routinely advise my clients to mine consumer complaints to identify consumer weaknesses and systemic risks. I also tell my clients that the Bureau loves to turn complainants into witnesses. And that is so true today. The acting director has advised the Consumer Education and External Affairs to, and I'm quoting here, redouble its efforts to ensure the Bureau engages all consumers who are economically suffering, ensure that consumers who submit complaints to the Bureau get the response they deserve. So I think complaints are going to continue to be very important to watch. In addition to preventing another foreclosure crisis, the Bureau is laser focused on tenant evictions. The acting director advised the Consumer Education and External Affairs to target Bureau resources to reach and help consumers in delinquency or at risk of foreclosure, as well as renters at risk of eviction to know their rights. Also to ramp up coordination efforts with other agencies to help provide information to at-risk homeowners and renters, as well as making sure that homeowners and renters can utilize how to prove housing counseling organizations to kind of manage those risks. And last, with regard to rulemaking, we've already seen a focus on mortgage servicing. With the rulemaking was recently finalized on June 28th with an effective date of August 31st. Among other initiatives in the rule, it includes a temporary special COVID-19 loss mitigation procedural safeguards that are in place before a servicer can initiate first legal action for either judicial or non-judicial foreclosures with certain exceptions. And the Bureau is also exploring options preserving the status quo with regard to the debt collection rule. Final rule Reg F was promulgated last year, but its effective date has been delayed, and we'll see if it does take effect. Next, turning to addressing racial equality, the acting director has indicated taking bold and swift action. He indicated to elevate and expand existing investigations and examinations and address new ones, to add new ones, I should say, to address inequality. We are already seeing broad information requests and fair lending examinations. And personally, in my practice, I've seen several with regard to mortgage originators, mortgage servicers, as well as student loan originators and servicers. Fair lending enforcement is a top priority. And we are already assessing companies with regard to fair lending enforcement actions. I think the first one literally came out within days after President Biden was sworn in. And then the CFPB has indicated that they're even taking a broader look beyond fair lending to identify, root out unlawful conduct that disproportionately impacts communities of color and other vulnerable populations. And I'll get back to that one in a minute, because I think that one's very interesting. With regard to consumer education, they are redoubling their efforts to ensure that the Bureau engages all consumers who are maybe economically suffering, and ensuring that consumer who receive complaints get the responses they deserve. So again, focus on complaints. Secondly, in order to, as they put it, reorient work squarely on consumers, the acting director directed Consumer Education and External Affairs to lead a refresh of the CFPB's website to focus on consumer rights and expand social media presence, to signal that the CFPB is on the consumer side, aggressively rebuild and repair CFPB relationships with consumers, civil rights, racial justice, and tribal and indigenous rights groups, as well as to collaborate with coalitions of stakeholders, including consumer advocates, civil rights groups, grassroots, community-based organizations, and individuals, consumers, to get to messages out to homeowners in the language and terminology they understand, which is looking at limited English proficiency issues. And last, on consumer education, the CFPB noted that consumer advocates have found disparities in companies' responses to Black, Brown, and Indigenous communities, and the acting director has asked the consumer response to prepare a report highlighting companies with a poor track record on this issue. And this analysis will be published. So more to come on that one. I don't have a sense of when that will be published. And then last, with regard to rulemaking efforts, there's a few here worth highlighting. I think I got 3 or 4, all of which are mandates under the Dodd-Frank Act. So the first one, and we talked a little bit a second ago about looking beyond, looking at fair lending more broadly to determine root out unlawful conduct. And I think this one at least goes to that area. So Section 1473 of the Dodd-Frank Act requires the CFPB, along with the Board of Governors of the Federal Reserve, Office of Comptroller of the Currency, FDIC, NCUA, and the FHFA, to develop regulations to implement the amendments of Section 1225 of FERIA concerning appraisals. And specific, this one is the FERIA require implementing regulations on AVM, automated valuation models. We have seen a lot in the press recently with regards to homeowners complaining discrimination in the appraisal process, and that borrowers in historically Black neighborhoods, properties are undervalued. And one of the things in the appraisal community that we see is that there could be appraiser bias. And one way to counteract that are looking at these hybrid appraisals, which would basically be an inspection of the property plus an AVM. So I think this AVM rule is important. Clearly, it hasn't been a focus for the last 10 years, even though there's a mandate in the Dodd-Frank Act for it. And I think that we're going to see renewed attention on that one. Also important are two ones that Director Kraninger highlighted when she spoke with Brian earlier today, implementing 1071 of the Dodd-Frank Act, which amended the Equal Credit Opportunity Act, ECOA, to require financial institutions to collect and report certain information concerning credit applications made by women-owned, minority-owned, and small businesses. So the next action there is a notice of proposed rulemaking. Third, Section 1033 of the Dodd-Frank Act, known as the Open Banking Rule, provides that subject to rules by the CFPB, covered persons shall make available to consumers upon request transaction data and other information concerning a consumer financial product or service that the consumer obtains from that financial institution. Just, I think it was last week, President Biden issued an executive order, and in that order, it encouraged the CFPB to consider promulgating rules to facilitate the portability of consumer financial transaction data, so consumers can more easily switch to financial institutions and use new innovative financial products. I believe the Bureau issued a proposal with regard to 1033 in 2020. And I believe that the next action on this is in April of next year. But Brian, keep me honest on that one. And I think this is one that's going to get significant attention. The last one that I want to highlight, which is not yet a CFPB initiative, I didn't see it in their rulemaking, but I think it should be on folks' radar to watch, is the Housing and Urban Development announced on June 25th, proposed rulemaking entitled HUD's Discriminatory Effects Standard, basically a proposal to rescind the department's 2020 disparate impact rule and restore to the 2013 discriminatory effects rule, as HUD believes that it's more consistent with the decades of case law, including the Inclusive Communities case. So this may be instructive how the Bureau may consider amending Regulation B to ECOA, which only minimally addresses disparate impact. As we have more going to have a focus on fair lending, you would think that would be something that they may be taking a closer look at. So that's a lot. So I'm going to pause right there and turn it back to Brian.
Thank you, Nancy, for that rundown. I think it's fair to say the Bureau has been busy over the last 6 months under interim leadership, which is somewhat unique. If you're expecting a caretaker, Dave Weggio is not that, and I think has proven that. Let me turn it over to the professors and maybe ask the same question a different way, which is, other than maybe the mandatory rulemakings, which undoubtedly will remain part of the agency's agenda, if Rohit Chopra is confirmed as the next director of the Bureau, do you think that those two main priorities articulated by Acting Director Weggio will remain the same, or do you expect that they will change? I'd hazard a guess myself, but I will confine myself to being a moderator of this discussion. But Professor Peterson, why don't I turn it over to you? Mr. Chopra, you've worked with him, I think, on 2 occasions. What do you expect his priorities to be? Is it going to be a continuation of the course that Acting Director Weggio has laid out with maybe an overlay, or do you think there'll be a wholesale change?
Well, thanks, Brian. It's good to be here, first off. And thank you for the invitation to the Federalist Society for putting together this conference. Also happy to be here with Nancy and Professor Wiki Todd. I do know Rohit. I don't want to overstate that. I mean, we're not besties, but we worked together at the CFPB back during the Cordray years. And we also both worked at the Consumer Federation of America, me on a part-time basis while I was teaching. And I think after he was appointed to the Federal Trade Commission, they were looking for his replacement. And I guess that was me. Some things about Rohit. First off, he is very smart. He is a very smart guy. And he has sky-high EQ. He's very intuitive and understands what's going on in the room. I've never played poker with him, but I anticipate he'd be a very good poker player if he gave it some effort. And he's also very compelling in meetings. You know, some people, I struggle with meetings because I get impatient in them. Rohit is very effective at working a room in a meeting. He also, in my view, has sky-high integrity and is very sincere in his commitment, which is utterly genuine, to try to make the country a better place and to use government to be a positive force in the daily lives of working people. It's not for him. I do not believe that it's about careerism. It's about making a difference for working people. I also might mention that unlike, Rohit is not a lawyer. Rohit is a finance guy. He worked at McKinsey as a consultant for 2 years, but he's just as sharp as any lawyer on rules if he puts his mind to it. So, and he's very energetic. I think that he's going to do a lot of stuff, and it's going to be thoughtful and tactical with a broader strategic vision. What specifically will he work on? Well, I don't want to say that I know, because I'm teaching now. I don't know what Rohit's talking about doing. But with the asterisk, this is all speculation on my part. So take it for what it's worth, which is probably not too much. I think that off the top of the list, I think one change will be that in the enforcement office, there will be a renewed focus on ensuring that the cases provide remediation back to consumers. And Brian, we can talk about this if you want, but I tracked the enforcement cases fairly carefully, and there were still quite a few cases that were coming along, but the overall amount of redress, restitution, or disgorgement, however you want to characterize it, being returned to the pockets of consumers declined, I think, pretty steeply in the last administration. I would anticipate that Rohit will insist that the cases provide remediation before he agrees to settle them, and will probably pursue pretty aggressively ensuring that customers get their money back. So second, some things that Nancy's rundown of what's going on at the Bureau right now in many ways overlaps what I anticipate will probably continue to happen if Rohit is confirmed. I agree that there'll be a continuing focus on racial justice and systemic inequality, one of the great issues of our time. And what that means, I think that I would anticipate that Rohit will be searching and creative and trying to find different tools to address that, both obviously Equal Credit Opportunity Act cases and supervision. But I also would think that there will be a focus on non-English language content and disclosures and an outreach to consumers. And I also agree with Nancy that automated valuation and appraisals is an interesting area where we might be able to provide some greater wealth by just recharacterizing how we're talking about the value of homes in minority zip codes. So those all seem to me like likely avenues for advance. I also think that, this might be too obvious, but Rohit was the first student lending ombudsman at the CFPB and ran the student lending office. And he has a very high level of knowledge about student loan servicing. And I think that we can expect that there will be a renewed focus on that. There are still, from the perspective of people like me, who spent their careers focusing on consumer advocacy, We view the student loan servicing market to be quite dysfunctional. Things like the failure to provide public service student loan debt forgiveness, adequate transition into income-driven repayment plans for student loan borrowers that are struggling to repay their debts. These are existing legal programs that were adopted by the United States Congress and implemented into law, but still do not appear to be delivered adequately to student loan borrowers across the country. I think that you can expect that Rohit will want to see some action on that and will attempt to use the Bureau's tools to deliver concrete results in that marketplace. I should stop and turn over to Todd, but maybe just a couple more things. I think he's going to continue to insist on high functioning in the student loan servicing market. When they're transition between servicers, dealing with the COVID-related servicing challenges. Folks that are running mortgage servicing markets need to stay on their game and make sure that customers are being taken care of. And then the last thing I'll mention, and I'll stop, Nancy also talked about it, but a real wild card is what happens with COVID. If it continues to decline, we may be transitioning away from that, and that may not see too much, but there's also been resurgence with the various variants, and whether or not, if there are major breakthroughs in the vaccines, or if we continue to see large populations of America not accepting the science on vaccines, we could see a lot of consumer harm from that disease, and that's going to creep into their consumer financial arrangements with their banks, their credit unions, and whatnot. And a lot to talk about that. I wrote a paper about it with Director Cordray and Diane Thompson, who is still at the agency, at the Bureau. Lots of details on that, but I know I need to stop and turn it over to Todd.
Yeah, Todd, let me jump in here, and I'll throw you a curveball. So this occurred to me in the context of our discussion here, which is Nancy laid out, the roadmap for what the agency has articulated as, its policy direction, and Chris laid out, his well caveated guess about the direction of, where Mr. Chopra might go if confirmed. The question that came to my mind, which I think you're in a good position to answer, is, does it really matter anymore? And what I mean by that is, post-SALA law, where the director can be removed at will by the president, does it matter so much what the director's policy preferences and priorities are, or does it, over time, does the agency begin to act more like an executive agency, and does the agency kind of get subsumed within the meta government infrastructure where rules are run through OIRA, where I know you worked at one point, and does the policy development process start being mandated through the White House, through NEC, and downstreamed to the Bureau? And so, are the activities, if we're trying to read the tea leaves and understand where the agency's going, I guess the other way of asking this question is, should we start, thinking what are the administration's main priorities and figure out where the Bureau fits into that agenda, as opposed to what used to be, I think, supreme in the CFPB criminology, which is figuring out what makes, an individual director tick and what can we expect based off of their unique histories and background and interests. So I'm riffing a little bit here, but, what do you think, happens with the agency post-SALA? Is it inevitable that they get pulled more into an executive agency posture, or are they going to hold tight and be treated as the independent agency that they were conceived to be?
Wow, that's a marvelous question, Brian. It certainly is a curveball. Before I answer that, first, I want to say congratulations to you for this slate of panels today in the Federalist Society, which has been fascinating to hear Director Kraninger and then Tom Pahl and David Silberman and my colleagues on this panel. I couldn't help but laugh when Chris said he gets impatient in meetings at his career choice to become a faculty member. Apparently he didn't know about faculty meetings when he signed up for that career choice.
I've had a lot of angst about that, Todd. Go ahead.
There you go. There's deception, that cause of action for deceptive. That's a great question, Brian. And as you were asking the question, I was trying to recall whether there's any historical precedence for this, which is we know during the 70s that and into the 80s that some independent agencies were reformed, some were abolished. The ICC was abolished, for example. Interstate Commerce Commission, I think many of its duties were merged into the Department of Transportation, as was the case with the Civil Aeronautics Board. Obviously, the FAA is a successor to that, and I'm not an expert on it, but it's a great question. I think it raises a couple questions, which is first that the agency, it's an unusual agency in that it is structured, really is structured very much like an independent agency in its internal guts, right? I mean, the fact that it has this well-developed administrative procedure process, the fact that that its budget is protected by Congress, of course, from Congress, which is sort of, and technically the president, which is a sort of a super independence type thing. From the beginning, it's always been sort of a peculiar way to think about this as it becoming an independent, as an executive agency, given so many of the features that structure like an independent agency, like I'm saying. It's also unusual. I was very struck by an observation that Director Kraninger made in her discussion with you, Brian, which is the way in which not just the budget, but also the fact that the only political appointment technically in the agency is the director influences the relationships between the director and the Hill, in that, as she mentioned, there's a lot of negotiation that goes on when you need to get your sub-cabinet appointments confirmed. Often that's a time for back and forth between the Senate and a department. So in that sense, Congress still, the Senate largely lacks that tool still for oversight. It's unclear how things are going to shake out on the budget. It's a very murky area at this point, which is what happens if still, the statute provides that the budget is provided from the Federal Reserve. But what happens if the White House tells the director, we want you to request X in your budget, and the director fails to do that? Obviously, it could be removed for that. But the Dodd-Frank legislation is kind of murky on what the technical authority is of the White House and the OMB over all of that. Obviously, the final thing is that this has been a very independent agency. They've tenaciously protected the independence of the agency, and the DNA is very much of an independent agency. The pattern of relationships between the agency and the Hill is kind of part of that legacy. And so I think seeing how that develops over time is going to be very interesting. The extent to which, as you suggested, you would expect it would come to act more like an executive agency over time. But given this sort of long run up and this fierce assertion of independence that we've seen from this Bureau from the beginning against both in theory, the president as well as the Hill, it may take longer to kind of digest this agency into the executive branch than might otherwise be the case. And that's one of the things I think is going to be interesting to watch here, is not just the development of relationships with the White House, but development of relationships with Congress. Obviously, Director Chopra is known to be very closely allied with Senator Warren, as was Director Cordray. And what will that influence be like with his views on the Hill? I think another interesting thing that I'm going to be interested in watching is what will be the relationship, and I think Nancy may have alluded to this, but the relationship between the CFPB and the FTC, that's been a very unsettled relationship over time. The CFPB during the Cordray term was relatively expansionist and imperialistic. And I know from my discussions with people at the FTC that ruffled some feathers. And in many ways, the chair of the FTC at that time kind of went along with that. The CFPB was kind of the cool kid in town. and there wasn't a lot of political gain to be had to standing up to the FTC at that point. And so questions like the, extending the CFPB's jurisdiction indirectly over auto dealers, for example, I know is something that rankled a lot of feathers at the FTC, and has kind of been pared back during Director Kraninger's term. I think this will be especially interesting to watch given the sort of surprise appointment of Lena Khan as the chairman of the FTC, in that she has very little background in consumer protection. Obviously, she's known for her work in competition. She also has very little experience within sort of the, let's face it, knife fighting of sort of interagency relationships that goes on in the federal government. And so,
well, Todd, not to interrupt you, but if there's anybody who's maybe well positioned to bridge that gap between FTC and CFPB, I'd have to guess it's a sitting commissioner who's the presumed, soon to be confirmed director for the Bureau. So I know there has been kind of a tension in terms of how the agency holds hands behind the scene on joint kind of collective actions. My guess is that there's probably an established relationship there, and maybe a smooth relationship. So apologies for interrupting there. I do want to make sure that we have time to talk about the other major question that I have here about the future of the Bureau, which is we've explored in some detail where we think the agency is going, at least in the near term. It's a wholly separate question on where should the agency go, and to some extent, beauty's in the eye of the beholder. If public observation of past Bureau activities is any indication, I strain to find a middle ground. You either hate it or you love it, depending on who's in control. And there seems to be not any kind of moderating middle right now, and maybe that's just a feature of the politics we're in. But I do think that there is important thinking that should take place 10 years out, evaluating where the agency is on its future. Both Kathy and then David and Tom all spoke to the idea of trying to depoliticize the agency and in some way get to regular order. And so, I think one way you do that is internal cultural change, but importantly, you should have a vision of what the not end state is, but where the agency is going. And I know, Todd, in full disclosure, I had a hand in the task force effort, but that culminated, under your leadership in a series of recommendations for the future. Professor Peterson, I know you've written extensively about, kind of hot button consumer protection issues, and have done a lot of deep thinking about where in the development of federal consumer financial law or consumer protection law and regulation generally, with a state federal interplay should go. So I'd be remiss if I didn't try and tap into your expertise in thinking on, what would be, your vision for how things should shape up, say, in the next 10 years. So brand new agency, went through the fits and starts of becoming a mature agency. Now that it has all of its resources, capabilities, faculties, has developed in-house expertise. Where do you see it going, or where should you see it going? And, Chris, I'd love to kick this to you first, and then maybe turn it over to Todd and Nancy for reaction or for additional thought.
Well, first, I agree that in Washington, there's still a lot of, it's obviously a football in the partisan war. But one thing you didn't mention in my bio, I was the Democratic Party's candidate for governor of Utah in the last election cycle. And so I spent a lot of time out in the hinterland, going around a very conservative, very Republican state. Obviously, I lost. I mean, it's Utah. I'm a Democrat. But I did get more votes than any Democratic candidate in the history of Utah. And what I found was that people really weren't too offended that I was a former CFPB guy. And when I started talking about consumer finance, the thing that Republicans agreed about, at least in my home state, was that we needed payday loan reform. A super majority of Utahns, of all people, support a traditional interest rate cap. And that's true all across America, which is far on the interventionist side from the most aggressive version of what the CFPB was proposing. I think that payday loan reform is right in the wheelhouse of the kind of thing that the CFPB was supposed to do to protect consumers from financial products that are not probably in their best interest most of the time. And obviously there's going to be disagreement with that on the panel. This is a normative thing. I think we need aggressive reform of that industry. Second, I actually
don't. Yeah, sorry to interrupt. You see that more as a state level or at the CFPB specifically?
Yeah, I mean both. I think that either some. I mean, it's not in my state. It's not happening, even though a super majority of Republican primary voters want it. It doesn't seem to happen, and there are a lot of complicated reasons for that. I'd like to see it at the federal level and the state level, or either. It'd be great if Congress would do something. I have a bill I drafted that's likely to be introduced, I think, by Senator Brown pretty soon, if it hasn't already. But in any event, I also, my second thing I'd like to say is actually it's consistent, I think, with what Todd was saying and what you mentioned, Brian, with the Supreme Court's decision in the AMG versus FTC case. The FTC is going to have real problems in providing consumer redress, but the CFPB still has very robust tools about that. I'm really hoping that Rohit, Director soon to be, I hope, Director Chopra will work on collaborative CFPB FTC enforcement to try to leverage those boots on the ground at the FTC to make sure that they can still deliver real benefits back to American consumers. I envision. And look, I realize this is going to take some collaboration, but I envision, FTC litigation teams that are mated with CFPB litigation teams, where FTC is driving some of the investigative work, and CFPB folks are being brought in to make sure that the remediation is happening back to consumers. Third thing I'll mention. I'm very worried about cybersecurity. I'm concerned that in Russia, Ukraine, maybe some other places, there are quasi-state actors that are, engaged in criminal activity, seizing computers in the United States. And if they manage to get into our financial institutions, that's going to run right up into the consumer protection laws that we have had for generations. And this is an area where we could have consensus. We need, banks want to have, and credit unions, other non-bank financial service providers want to have secure systems. And if they don't have secure systems, if they're getting hijacked, then it's the customers who are going to be in real trouble. We need to be proactive in trying to address that. And that could mean collaborative relationships with the State Department. And we need to have a bold vision for how to secure our financial systems to protect consumers and industry. Fourth thing I'll mention, I think that I am very concerned about where we're headed with respect to climate change and the nation's financial industry. We have in our country, one of the great inventions of American society is the 30-year fixed interest rate mortgage. It helped build our middle class after the New Deal, where the basic deal is this: if you're about 30 years old, 35 years old, you've got enough money to make a down payment on the house, you can, over the course of your lifetime, with a low fixed interest rate loan, manage to acquire property and become part of the landed gentry and leave that to your progeny by the end of your working life when you retire. But the problem now is that the best scientists that focus on this believe that in 30 years, 50 years, 60 years, and nobody knows for sure, much of our seaboard is going to start to go underwater. And we're already starting to see that with the collapse of a tower in Miami on Miami Beach. Do we need disclosures on that? How are we going to deal with 30-year fixed interest rate mortgages, one of the greatest inventions we've ever had, still being made on property that is likely to be underwater in the foreseeable future, perhaps within the due date of the promissory note that the consumers are signing? Last thing I'll say, and I gotta stop turning over. I think that my normative point is that we need to move fast. Ordinary consumers do not understand why it takes so long for rules, for enforcement cases, for changes in policy to be enacted. Already we're well into the 2-year policymaking cycle, and the director's not even confirmed yet. And I know it feels like a lot of stuff's going on for people who are watching inside the Beltway, but out in the provinces, people aren't really feeling a lot of this. They don't understand. They don't see that changes in their daily lives are being made. Rohit needs to move fast to make concrete decisions, try to deliver value to the American public. I'll stop.
Chris, I'll just note before turning over to Todd, I was really struck by your notion of the integrated FTC, CFPB activities. You might want to work on a paper with Todd, because I think he's spoken to the notion of combining the two agencies. So maybe there's some common.
Todd and I, we get in a fight as soon as we start talking. I don't know if it's possible. It'd be an interesting paper if we could manage to sort it out.
So Todd, you obviously, chaired the task force, which I think is, at least in recent years, the kind of definitive, kind of forward-looking statement about consumer financial law and policy. I know folks are reacting to that, agree, disagree, et cetera. But would love your take on where you think CFPB policy development should go, what you envision, the next 10 years, say, of CFPB activities. Where should things be headed?
Sounds good. Well, I've got 101 ideas of recommendations, so I'll just mention a few. The first is one of the things we call for in the task force report is, and Tom Pahl touched on this, so I won't belabor it, is sort of thinking coherently about tool usage, which is the CFPB is an unusual, and as far as I can tell, unique institution for consumer protection bureau in the world, in that it has 5 tools: enforcement, supervision, regulation, consumer education, and research. And as Tom Pahl touched on, it's not always been clear the way that whether the CFPB has thought strategically about how to use all those tools in combination. And related to that may be a consideration of internal reorganization, perhaps around markets rather than around tools, which is something that we suggest in the task force as well, which is thinking about a problem from the perspective of how consumers shop for a product and how markets work, and then thinking about what the right tool is to do that. Whereas what Tom suggested, it seems like sometimes they pick a tool and then decide kind of work backward from there as to how the issue will be approached. I think a second thing is that Director Kraninger touched on that I want to endorse very much is she pointed to the innovation agenda of the Bureau over the last few years, headed up by Paul Watkins in particular, which got started on Director Cordray. I think that is a hugely important thing in order to promote not just innovation, but innovation for the purpose of promoting financial inclusion and competition. And related to that, as well as I strongly endorse the point that in the White House EO about promoting competition in bank accounts, except that I might say maybe it doesn't go far enough. I'm not sure that sort of just portability of account information is enough. I would like to see more. Perhaps really thinking about how to create a more fluid banking system that makes it easier for people to change accounts, much like they can change credit cards and prepaid cards right now. And I think that would promote greater competition and perhaps make banks more responsive to consumers and create more innovation in that market. We also talk about just generally about competition and strengthening. The Dodd-Frank tells the Bureau to take account of the impact of their rules and practices on competition. And we have a number of our recommendations. I think that is something that should be elevated within the Bureau. And hopefully a director Chopra, who comes from the FTC and is used to the idea of thinking about the interface between competition and consumer protection, he may be able to think about how to effectuate that policy of competition. A final thing that I think would be useful to think about, and one of the points we called for is, and this relates to the tools usage question, which is we suggest greater reliance on principles-based regulation, as well as being more proactive in terms of crisis management, which is to say, in the past 20 years, we've had three major crises that have affected consumers: Y2K, the 2008 financial crisis, and now, of course, the pandemic. And I think the federal regulators did a great job using the tools at their disposal and sort of making things work through COVID. But I think it might be useful to have the regulators themselves kind of stress test their mechanisms, and perhaps have Congress grant greater authority to the agencies to respond. So, for example, a lot of states have a lot of special interest provisions that protect notaries and require in-person real estate closings and all this sort of stuff that were obviously a disaster during the pandemic, and the FTC managed to cut through that while you were there, Brian, I believe, and it did a great job with that. But it would be nice if there were greater provisions for that, as well as principles-based regulation. In terms of writing these long, detailed, prescriptive regulations, think about how to use regulation perhaps in a more integrated way with supervision and rulemaking, supervision, research, and the like. And I'll turn it over to Nancy to bring us home.
Yeah, Nancy, I'll give you the last word. I mean, you've obviously been a close observer of the Bureau and consumer finance topics generally, even before the Bureau. You know, what would you like to see, come from the Bureau, be it from a client perspective or a business need perspective or a personal perspective?
Yeah, no, thank you. I mean, I agree with a lot of what, Chris and Todd have said. And from my perspective, look, I advise clients on these issues all the time, but I'm also a consumer. And, and I use my consumer hat, and it kind of instructs me on how I advise my clients and how I think about these issues. So, I'll just highlight two. I think this question we probably can talk about for hours, if not days. But two that are top of mind for me is one, clear rules of the road. So, companies really want to do the right thing. And a lot of times they're just like, yeah, but we're not even sure. And I can give two, very timely examples. One has to do with credit reporting for borrowers who exit forbearances, who for whatever reason decide not to engage in some sort of permanent loss mitigation option. The CFPBs provided guidance in an FAQ 10 that is just really unclear, doesn't address the situation, despite numerous attempts to seek clarity from trade groups and others. They just declined. So they leave companies just not knowing what is the right thing to do there, and which, rather than a gotcha mentality, it would be really nice to give clear guidance when a specific issue has been presented. The second example I can say is the Hunstein case that came out of the 11th Circuit recently that discusses with regard to debt collectors, what information you could use to have service providers conduct or not without violating the FDCPA. Again, the issue is not clear, and the Bureau declined to provide guidance. And maybe that one's a little different when there's active case law. But again, I think, now we have, a circuit case that's, the law in, 3 states that are subject to the 11th Circuit. It would be nice to have guidance there. So clear rules of the road would be number one. Number two would be I do like the idea of coordinated, regulation and enforcement between the federal and the states. But in my experience, what it turns to, is particularly with non-banks, is now you have 54 regulators all looking at the same thing. So it makes it really expensive for companies, and that just gets passed down to consumers. So, federal preemption has been kind of, I would say, out of style in the last several years since the Dodd-Frank Act that amended the preemption standard. And I think that's something that needs to be revisited on how we can ensure that there is adequate consumer protection, but not making it so uncostly for companies to do business and trying to deal with 54 regulators. So.
Well, I think we have hit our mark almost exactly. I have 2:59. Thank you, Todd. Thank you, Chris. Thank you, Nancy, so much for joining me on this panel. And thanks to the audience for joining the entire conference today. And thanks especially to the Federal Society for hosting today's event. This now concludes the conference. Thank you very much.
Thank you.